Hi. If you haven't watched the last two videos, I recommend that you do because they set some important context. The law recognizes various kinds of rights. Some of these rights are recognized by the law itself, that is, by statute or by custom. Some are recognized by the Constitution. These are, of course, called constitutional rights. There is, however, one special class of constitutional rights which are called fundamental rights. What makes these rights special or fundamental is that even a law cannot take these rights away. Therefore, if the Supreme Court or any High Court finds that a law violates or takes away from a fundamental right, they can strike down that law as being unconstitutional. Most fundamental rights can be enforced only against the state, that is, government, parliament, the state legislatures, etc. Most fundamental rights, therefore, cannot be enforced against other private parties like individuals or private sector companies. We will probably visit this subject on a different occasion, but since many fundamental rights can only be enforced against the state, looked at from the other direction, fundamental rights are in fact restraints on the powers of the state, or, in other words, what is a right of a citizen or a person is a restriction on the state or the government. One thing which all 5 judges of the Supreme Court who heard the Shuprio case agreed on was that there is no fundamental right to marry. Let's find out why. The Supreme Court said that marriage, while not a fundamental right, was nevertheless a legal right which came either from statute or from custom. The Supreme Court found that marriage was essentially a personal preference, and the exercise of a personal preference cannot be compelled by making it a fundamental right. That is, you cannot force a person to exercise a preference. The court also said that the mere fact that something is important to an individual does not justify its being treated as a fundamental right, even if there was popular or public acceptance or support. Marriage, the court said, existed well before the law and the state or the government. It is a right recognized by the law, but it is not a right conferred by the state. Marriage can be regulated by the state but cannot be abolished by it. How can there be a fundamental right to marry if the government has the power to regulate marriage and the fundamental right effectively takes away from that power of regulation? The court then compared the Indian and Irish constitutions. It noted that the Irish constitution recognized the family as a unit and the ability of a family to enjoy rights. However, it also noted that the Indian constitution does not recognize the family in that way. Most rights in the Indian constitution are conferred upon individuals. Considering that marriage is a path to the creation of a family, and that the Indian constitution does not really recognize the family in the same way that the Irish constitution does, the Supreme Court said that there could not be a fundamental right to marry. The Indian constitution does not put the family above or maybe even at par with the individual. The court also found it difficult to precisely define the term marriage. There are some statutes which define this term, but then the Constitution lies above statutory law, and a definition in a statute cannot be used to introduce a concept into the Constitution. For this reason too, the Supreme Court refused to treat marriage as a fundamental right. So the right to marry is not a fundamental right. Is it a legal right? Clearly it is. There is both statutory law and customary law that recognizes the right to marry. But this is where the case met its next obstacle. The Supreme Court found that there is neither statutory law nor customary law which recognizes non-heterosexual marriage. It is in this context that the court examined the Special Marriage Act. Those supporting non-heterosexual marriage contended that the Special Marriage Act discriminates against non-heterosexual or queer people by failing to recognize non-heterosexual marriage. All 5 judges agreed that the Special Marriage Act did not discriminate by failing to provide for non-heterosexual marriages. The court noted that the Act was never intended to provide for non-heterosexual marriage at all. It was only to permit marriage between two people of different castes, communities, or religions. The court observed that if the Special Marriage Act was to be struck down on the ground that it did not provide for non-heterosexual marriages, that would take us back to the pre-independence era, or, as I'm sure you recollect from the earlier video, the Special Marriage Act 1872 or even times before it. The court did have the option of interpreting the provisions of the Special Marriage Act or some words therein to include non-heterosexual marriage and to permit it. But the court refused to do so, saying that that was law-making or the legislative function which the court or the judiciary could not perform. Not only can the court not make law, it also cannot compel the legislature to make law. Interestingly, the court also found that the Special Marriage Act was never intended to contemplate non-heterosexual marriages, because at the time when the Special Marriage Act came into force, the law still criminalized non-heterosexual sexual intimacy. When sexual intimacy itself was criminal, remember Section 377 IPC, it is not possible that the Special Marriage Act intended to cover non-heterosexual marriage. The court also analyzed various provisions of the Special Marriage Act and found that the Act only contemplated heterosexual marriage. While the Act did intend to provide for unconventional marriages or marriages that did not find acceptance in society, the court described it as being too much of a stretch to say that this would include non-heterosexual marriage. So the court interestingly found that the need for a law that governed and permitted non-heterosexual marriage today was identical to the need for the Special Marriage Act in 1954. Effectively, therefore, the court said that it or the judiciary could not perform this function, but the legislature ought to perform that function. That, broadly, is what everybody agreed on. It is at this point that they disagreed. Two judges, that is the minority, said that since cohabitation or the right to cohabit or live together is a fundamental right, the state is compelled to recognize such cohabitation. Effectively, these two judges said that the state has to recognize live-in relationships. They went a step further and said that upon such recognition, various rights which are ordinarily conferred only on married people are to be conferred on such live-in relationships which they called civil unions. Some of these rights were described in the last video. These include things like income tax implications, adoption, legitimacy and succession of children, etc. These two judges described these civil unions as atypical families. They said that this is because they are families, they are just not families which are founded on marriage. They said that the failure of the state to recognize such atypical families violated the fundamental rights of the partners of these civil unions. In a way, doesn't this structure sound like a marriage without marrying? The majority disagreed with this. The majority said that the rights that the minority seek to recognize in civil unions are rights that come from marriage. The majority also said that the court cannot create a legal regime in this manner and that is actually legislation. It also said that the court cannot facilitate the creation of a social institution. The majority also took the view that the regime or the system that the minority sought to create would be difficult to implement, because if all these rights were to be recognized in civil unions or live-in relationships, a whole different framework of rights and obligations would have to be created, and that the court or the judiciary was not equipped to perform this function. The majority also took the view that the judiciary must intervene only when there is a threat to the assertion of fundamental rights, but not when the mere free exercise of those rights is in question. It also said that the concept of equality in the Constitution did not mean that all laws were to apply to everybody in the same manner in an equal way. They said that merely not providing for one category of cases would not itself be treated as discriminatory. There were other reasons too, but these were the broad strokes. That was quite a bit, wasn't it? Too many things to consider, too many points of view and competing ideas to reconcile. Anyway, to summarize the Supreme Court's conclusions, there is no fundamental right to marry. There is a legal right to marry, but such legal right is conferred either by statute or by custom. There is no statutory or customary recognition of non-heterosexual marriage, and the Special Marriage Act is not discriminatory merely because it failed to recognize non-heterosexual marriage. Most importantly, the court also held that the court itself cannot step in to create a legal right. It is only the legislature which can do that. So, is there a fundamental right to marry? Was the minority right in saying that the civil unions ought to be recognized and protected with the same rights that married couples have? Was the court overall right in its conclusions? Do you think it is only the legislature that can create a right to marry? The interesting thing about judgments on important social issues is that while in a court a judgment is most often the conclusion, in society a judgment often is the beginning of a debate. Thank you.